Every textbook on international human rights starts with a statement about the universality of human rights. It is usually stated that the principle of universality of human rights is the cornerstone of international human rights law. This principle, as first emphasized in the Universal Declaration of Human Rights in 1948, has been reiterated in numerous international human rights conventions, declarations, and resolutions. The 1993 Vienna World Conference on Human Rights, for example, noted that it is the duty of states to promote and protect all human rights and fundamental freedoms, regardless of their political, economic, and cultural systems. However, these days, more than ever, this universality has been questioned. More than ever, there are claims that human rights need to be interpreted context-based, and their scope and content depends on specific circumstances of the state. Even those countries which have previously adhered to liberal approach to human rights have time to time shifted to what can be called a hybrid approach to human rights to explain restrictions on certain human rights and diversions from international human rights standards. My talk today is based on an article in Process. This article analyzes new debates and challenges related to the accommodation of different religious needs in different settings, education, work, but most of all public space, ignited, but perhaps more rightly said, fueled by the current security debate and European refugee and migration crisis. This article uses Baltic states and Russia as a case study. The Baltic states are increasingly interesting case study because in this location many geographical, political and historical factors come to play. Soviet past, nexus to Russia, belonging to various regional and global structures such as EU, NATO and etc. These factors, by the way, have made Estonia and the University of Tartu also an increasingly interesting place for studying and pursuing a degree in human rights law. However, in this short presentation, I'm not going to into detailed comparison of mentioned states, but I will rather point out some general issues that I address in the mentioned article and that may have importance in other contexts as well. Such as the question, is the theory of human rights in the process of being rewritten? I will try to address the question whether the narrative of human rights is changing in the current emotionally charged and turbulent environment, and if, to what extent these changes are dangerous to all human rights. I will also argue that history and context have multiple roles in this process, which can be both negative and positive. I'm using freedom of religion or belief as an example of my arguments. Freedom of religion or belief is a good example, as it is perhaps one of the most sensitive and most debated rights today. Many problems under scrutiny in this article are very similar to those faced by other European countries, and not only by European countries. However, contexts do matter, and every country is slightly different. These differences in context do have effects on how international human rights, and more specifically freedom of religion or belief, are perceived and implemented today, whether we like it or not. One of these factors determining this context is history. It is needless to say that histories have significance in shaping the present and the context, social, legal, political, where human rights and freedom of religion or belief are operating. For example, a common Soviet past may have a lasting effect on how we understand human rights, including freedom of religion or belief, both in a positive and in a negative sense. In Soviet times, religion was seen more as a problem that needed to be dealt with gradually. One of the main means was to separate school from church. After the collapse of the Soviet Union, we witnessed a reintroduction of religion at schools. However, this has not occurred without debates and different understandings of how exactly religious education, confessional or non-confessional, should be provided, particularly through the public school system. For example, until rather recently, the form and content of religious education was hotly disputed in Estonian media and in academic educational circles. Although now a compromise seems to have been achieved in Estonia, it is accurate to say that many aspects of religious education are still unresolved. There is an agreement that education about religions needs to be provided in public schools and that private schools can provide confessional education. However, not all public schools provide it, and there is still a lack of qualified teachers and materials. There are several background factors which seem to influence the debate on religious education. The absence of experience for some 50 years in providing and receiving religious education in Estonia due to Soviet occupation is probably one of the most important factors. However, the relatively secularized nature of Estonian society and low numbers of affiliation in religious organizations play a significant role as well. The bottom line is that in current challenging environment, a simple lack of knowledge about different religions, but also about religious freedom and generally about human rights, may contribute to leaning towards more restrictions. This hangover of Soviet times in this region of seeing religion as a problem gets amplified, or if you wish, resurrected in the current security context. There are other factors alongside history that determine the circumstances for human rights and freedom of religion or belief in the present day. And for example, identity politics, the refugee crisis, security concerns, the battle between individualism and communitarianism, etc. But also, frankly, issues with simple tolerance, respect, and accepting the difference in diverse societies. As the Speaker of the Estonian Parliament at his visit to a security forum in Ukraine pointed out not long ago, currently there is a battle of open and closed worldviews going on in Europe and beyond. One can argue that this battle in the post-Soviet countries can also be seen as one of the echoes of Soviet times, filled with suspicion of otherness and lack of individual freedoms. Simply put, the experience of democracy has been too short. It is probably true that all textbooks published after the Second World War start the story of human rights not only about universality, but also more profoundly from human dignity. Dignity is captured also in the multiple human rights instruments. The United Nations Declaration of Human Rights states that all human beings are born free and equal in dignity and rights. The ICCPR, International Covenant on Civil and Political Rights, adds recognition of the inherent dignity and of the equal and inalienable rights of all members of human family is the foundation of freedom, justice, and peace in the world. Despite the differences in understanding of dignity, whether it comes from religious, philosophical, or historical origins, or its internal contradictions, You may have heard of dignity being a double-edged sword. Nevertheless, it has been a lighthouse or placeholder, using Chris McCrudden's terminology, to keep human rights on the right course. However, there is an anxiety and tension in Europe and beyond. Some see everything in terms of civilizational conflict, be it robustly termed conflict between Christian Europe and Islam, or even between liberal rights and cultural religious identity. The truth is probably that the social and political situation and atmosphere is changing very quickly, and it has become increasingly more complex to rationalize over the processes that take place. The recent migration crisis and current developments in the US migration policies have also contributed to the tensions. Proposed solutions to the tensions have varied from strong claims for more religion, also traditional religion, culture in the public sphere, to strong claims of no religion in the public sphere, for example, akin to French approach. In Europe, tighter rules have emerged to tackle both real and imagined threats to security. The proposals for new laws dealing with religious symbols and also hate speech have emerged and circulated in governments, including Estonia. The outcome of these debates is uncertain. It is perhaps correct to argue that both individual and collective freedom of religion or belief for all has become an endangered species of human rights in this atmosphere. One can also argue that there is a securitization of religious freedom in progress. We can understand security in a narrow sense, meaning physical security and personal integrity, but also in a broader sense, amounting, if you wish, to a general well-being, including a social and economic one. We can also differentiate between subjective and objective security, depending on whose perspective security is being assessed. The tensions in society have made some politicians and scholars to argue for more security, in narrow but also in a broader sense, and for security as a meta-right, right of rights, or as a fundamental right. We are witnessing the securitization of rights, a phenomenon that intensified after 9/11. Securitization theory itself has evolved since the 1980s, and since the 1990s there has been a steady increase of literature related to securitization of religion. Today we can say that there is no shortage of scholarly works on the matter internationally. Case studies relating to Islam, the Orthodox Church, and also so-called new religious movements have been the focus of many studies. John Reid described the right to security as the basic right on which all other rights are based. Franco Frattini, a former European Commissioner responsible for justice, freedom and security, has considered the right to be a precondition for all other freedoms. In this context, one can ask here if the story of human rights is being rewritten from other starting points rather than dignity. Lazarus argues that there are a number of arguments why the right to security cannot and must not displace the non-instrumental values of liberty, dignity and equality as the grounding foundation of human rights. She quite rightly points out that framing security as a meta-right gives it a subtle and different weight in the balancing process, that it thus if it is only considered to be a collective goal or, for that matter, a specific right. She also argues that it is imperative that we keep the scope of the right to security distinct and its content specific. By limiting the scope of the right to security, we can tame not only extensive claims to security, we can secure rights. So we need to be specific. One also should not forget that at the international level, human rights claims can only be submitted against states. And if the state has a right to a security trump, using Dworkin's terminology, then the outcome for human rights can be frankly quite miserable. From the above, one could argue it is important to stick to the idea of human dignity and avoid trying to rewrite the story of human rights from the point of view of other preferences. This rewriting may have dramatic consequences. Human rights are a significant achievement, but they are a very fragile ones. Do not get me wrong, security is important, but we should not give it a status of a meta right that can be used and abused by governments. Lazarus, for example, interestingly points out that there should also be right not to be secure. Thus, as McCrudden argues, the concept of human dignity plays an important role in the development of human rights and adjudication, not in providing an agreed content to human rights, but in contributing to particular methods of human rights interpretation and adjudication. To conclude, even if we do not agree on the origins of dignity, it can be argued to have a common core. Every human being possesses intrinsic worth merely by being human, the ontological argument. This should be recognized and respected by others, and some forms of treatment by others are inconsistent with or required by respect for this intrinsic worth, relational argument. We should not lose sight of this common core. The state should exist for the sake of an individual human beings and not vice versa, the limited state argument. Thank you for your attention.